and he's asking about cases that show judicial power. And I think you've given us some great ones, obviously with Marbury versus Madison. And but he was wondering, in addition to those, so I guess the first ones would be McCulloch, Maryland, and Gibbons, Ogden. But is there another case or two that you?
This is where you would go to for example, the contract clause cases. Okay, and there are a lot of lesser martial decisions, but the contract clause cases are significant because they limit the power of states to regulate economic activity. And those would be like Fletcher v. Peck, Dartmouth College. Fletcher v. Peck was 1810, Dartmouth College was 1819. Those are significant Marshallian decisions which use judicial power to, again, advance Federalist goals because Federalists wanted to protect private property above all things.
Okay, excellent. So this is a fun question. It comes from Crystal Cotty, and she asks, is there a good argument or reason why Supreme Court justices should be term limited rather than lifetime appointments? You want to talk about that whole situation?
Yeah, in fact, that's one of the things that you might use with your students. In fact, let me write down. That's a hell of a good question. I'm going to turn that back on the teachers when they go into their breakout sessions. Let me give the reason why you don't have term limits, and then we can talk about whether this is a good or a bad idea. The reason you don't have term limits is because the founders were devotees of Montesquieu, who they referred to in the Federalist Papers as the celebrated Montesquieu to distinguish him from like Montesquieu the plumber or somebody. But Montesquieu had, in the spirit of laws, developed this notion of the science of politics. And the science of politics was designed to create stable Republican government. And he said there were four parts to it, okay? One is separation of powers. One is institutional checks coming from separation of powers. Third is representation, so the people don't directly govern, their representatives do. And fourth is a life tenured judiciary. And the reason you need a life tenured judiciary, Montesquieu argued, is because if you make the judiciary at all dependent on the people, they will, in fact, reflect the will of the people and not the will of the law. And if the Constitution is law, it must govern in all things. So it's an effort to insulate justices from popular whims. And if you didn't have them life tenured, whatever authority the court had exercised could change with elections. Now, and again, this is one of the cool things that brings this back to the present day. That's exactly what you're looking at right now. And you'll be looking at that in the discussion of whether or not to expand the size of the Supreme Court. Getting term limits at this point in time is probably a pipe dream because it would require an amendment to the Constitution. And it's hard to imagine 2/3 of the states or 3/4 of the states agreeing to anything, even if you could get 2/3 of each House of Congress to do it.
Excellent. So our next question has to do with Andrew Jackson and John Marshall and how, Jackson famously ignored Marshall's ruling. And the question is, I guess, two parts. One, what was Marshall's reaction in that situation? And the second part is, are there other examples of presidents ignoring Supreme Court decisions?
Oh, sure. On the latter point, if you think about, for example, decisions dealing with affirmative action, okay, where the court has extended or said affirmative action is constitutional. President Trump, President Bush, man, I like to call Bush the library because his father's library is at Texas A&M, and Bush A&M and also Reagan opposed affirmative action. And they said it was unconstitutional. And there were instances where the court said it was unconstitutional as well, but those policies continue, okay? Because again, remember Hamilton's admonition in Federal 78, the court has neither sword nor purse, it simply has the power of judgment. And if somebody's willing to enforce these rules or not enforce these decisions, they'll either be enforced or not enforced. Think about the debate over abortion, for example. abortion has been a constitutional right since 1973. Um, there are still people arguing that it is not. And in fact, Republican presidencies, because the Republican Party is generally opposed to policies of abortion, have refused to extend funding, et cetera, and have tried to deny funding to Planned Parenthood, for example, to stop abortions. But abortion is constitutionally permissible, but they're trying to stop it because they don't agree with it. So there are instances where presidents have disobeyed court decisions, both overtly and sort of covertly. How did Marshall feel? By the time you're looking at Worcester v. Georgia, you're looking at late in Marshall's life. And realize Marshall was hanging on. And toward the end, he was somewhat infirm. And he had surgery, I think bladder surgery without anesthesia because they didn't have anesthesia then. He was in his late 70s. His wife had died. I think this was the last gasp of Marshall trying to extend the authority of the court to stop what becomes the Trail of Tears. And Jackson didn't say it probably, but it's a great line even if he didn't say it. Chief Justice Marshall has made his decision, now let him enforce it, because Jackson wasn't going to. So Marshall, no doubt, was frustrated that Jackson didn't enforce the decision. But by this point in time, Marshall's days are waning. Okay, the court's personnel had changed over time. He had less authority because he was not able to have his band of brothers that he had in the early years, and he was able to maintain into the 1920s. And he was in physical decline, and ultimately the court becomes Roger Taney's. And Taney is like the mirror image of Marshall on most things, but not on the question of judicial power. He used judicial review to strike down the Missouri Compromise in Dred Scott.
Yeah, that's really interesting. I think it's important context that that is the end of Marshall's career, and maybe something like that would have happened earlier. He would have had a little more fight about it. Well, hey, so you've given us these amazing primary documents, and so why don't we turn to those?